Hello everyone, and welcome to the third day of our conference, the scripts and settings of transitional justice, procedure, protocol, and form. This session is going to be on private law processes and reparations in transitional justice. I am honored to have here on this panel my dear friend and colleague, Professor Mayo Moran. Let me introduce her first and then explain a little bit about the way this conversation is going to take place. So Professor Mayo Moran serves as the Provost and Vice Chancellor of Trinity College in the University of Toronto. Prior to this, Professor Moran served as the first female dean of the Faculty of Law at the University of Toronto. Professor Moran publishes extensively on comparative constitutional law, legal and feminist theory, and historical injustices, among other topics. Her book, Rethinking the Reasonable Person, examines how judicial ideas of normal behavior may discriminate against women and girls. She has co-audited the Residential School Litigation and Settlement Special Edition of the University of Toronto Law Journal. And her current work focuses on the role of law in redressing historic injustice. This is going to be her much awaited book, The Problem of the Past and How to Fix It, which is forthcoming in Oxford University Press. Professor Moran's research has been informed by her involvement in public service. She has chaired the University of Toronto's expert panel on sexual violence policies and co-chaired the Faculty of Law's response to the Truth and Reconciliation Commission committee. She also served on the Council of Ontario University's reference group on sexual violence, and since 2007, Professor Moran has chaired the independent assessment process oversight committee that assists in the implementation of the Indian Residential School Agreement. In addition to numerous other awards, in 2012, Provost Moran received the IMCA Woman Distinction Award. So welcome, Mayo. This panel will be conducted as a conversation between me and Professor Moran. We will begin the conversation, and after about 30 minutes discussion, we will open it to questions from the audience. You are all encouraged during the conversation and after the conversation to use the Q&A device or chat in order to send your comments or questions. I will collect them and try to deliver them to Professor Moran. So, welcome, Professor Moran, and let us begin our conversation. In this session, we are going to focus on transitional justice through private law. So my first question to you is, how do you see it relates to the Nuremberg and Holocaust as a model for transitional justice? As we began this conference with the keynote lecture on Nuremberg. So now it's our turn to look at it and its connection to private law transitional justice.
Well, thank you so much, Leora, and all organizers. It's wonderful to be able to join you from Toronto. Just to begin, I think that the issues that were litigated around the Holocaust in the 90s, and Leora, your work, I think, has been incredibly inspiring for people outside of Israel and in established democracies where voices that have found it very, very hard to raise their concerns about the injustices of the past have started to look to private law using that Holocaust litigation from the 90s as sort of a source of inspiration and as a kind of a model for how to raise things that have been impossible to raise. And one of the topics, and I must say I was very pleased this time to hear reference to Canada's residential school situation, because until very, very recently, no one was bringing together the discussions around the problems of the past in established democracies with transitional justice discussions. Cynically, I might say that those of us in established democracies, academics, prefer to look at other places and talk about how those places needed to reckon with their pasts, rather than looking at our own reckoning with our own pasts. And so, you know, the Holocaust litigation in particular of the 90s, which I think you and your book on this is wonderful, opened up the lens to institutional level liability and beyond the criminal model, was incredibly, incredibly important for really shifting the conversation in very dramatic ways.
So what you mentioned is the litigation of the 1990s, which is what we call belated justice, because it took 5 decades after the Nuremberg trial that and the need to rely on transnational class action litigation, not in Europe, but in US courts, in order to finally address the responsibility of the business sector, banks, insurance companies, and the business corporation as such. And if you remember yesterday in the panel of archives, it was mentioned there how difficult it is to get corporations to open up their archives. And this difficulty is doubled in the case of the Swiss banks that were hiding behind bank secrecy and Swiss criminal law. So, but it also raises huge difficulties when we deal with institutions like churches and faith institutions. So, and this is your work. So before we move to the challenges, I wanted you to maybe expand a little bit on what do you mean by private law transitional justice in non-transitional regimes? Yeah. Can you say a few more words about it?
Yeah, I will absolutely do my best, and thank you. And I think the discussion around apologies, around the issues with archives, as you've said, the use of truth commissions, all of these institutions are institutions, processes, procedures that have been sort of taken. The models have been taken from transitional justice and are now moving into established democracies using private law litigation as the lever that gets those processes to happen. And so when I say, you know, transitional justice in non-transitional regimes, let me just explain a little bit. And I'll start with the classic version of transitional justice that Rudy Teitel gave such a terrific name to in her groundbreaking work. And that involved the insight that political transitions that involve a sharp break within a liberal past create distinctive rule of law problems. And those problems then give rise to a distinct set of processes and tools in response. And that's you know, obviously the topic in many ways of this terrific conference. And so my interest has been to look at a different kind of transition that raises related problems and also prompts reaching for very closely related solutions. The impetus to address the problems, though, and to reach for the solutions is very different. It's not regime change. And that's where private law comes in. So in stable legal orders, I think the transitional justice issues that we see, they arise because of normative and legal transition over time. Our values change. I mean, I'm sort of an optimist, so I would say our values improve. These issues pose dilemmas that are not unlike those that are manifested in political transition. They usually arise out of what we now view as massive human rights abuses perpetrated on populations that we dehumanized, racialized groups, people with disabilities, children. And so if we look at how these problems arise in stable regimes, we can see that the persistence of sovereignty and what I would call the proximity of the past creates its own set of problems. They're different problems than regime change, but they're critically important. And I think the most important problem is that countries like my own and many other established democracies really do not want to look at the past because it is our past. We don't have regime change to distance ourselves. And so that's exactly where private law comes in. Typically, what happens in countries like mine is that the people who want to raise the issues of massive dehumanization and violence and indeed genocide, they don't have political clout, and their voices are not heard in the political arena. And so really, the only tool they have is private law. And they have used private law very, very effectively to force a reckoning with history. And I'll just briefly mention, because I think it's a good example, and I was pleasantly surprised to hear a number of speakers refer to it today, Canada's residential schools process. So as I think you know, but I'll just briefly mention that for about 150 years, the government of Canada, and it did this in partnership with a number of churches, forcibly took Indigenous children from their families, put them in schools. They were given numbers rather than names. They were punished for speaking their languages and practicing their spirituality. They were not educated well, most of them, and too often they were abused physically, sexually, and spiritually. This was part of colonizing our country. It's what Jeremy referred to on Monday as our original sin, and it helped make our country and our way of life possible. The last schools didn't close until the 1990s, and really no one spoke about them, including in Indigenous communities. But in the early mid-90s, inspired, as I say, by two things, the Holocaust reparations litigation and transitional justice developments in South Africa, survivors started to bring claims to court. And those claims mounted at an incredible rate, partly because of pent-up trauma, partly because of some really unscrupulous lawyers. And so by 2005, the federal government said it was going to take over 50 years to resolve those cases. Settling was really the only solution. And the settlement agreement between 72 parties, pretty complicated, but it set up what may be the most ambitious transitional justice style effort to reckon with an illiberal past in an established democracy. It created a truth commission. It created a national center with extensive archives, national commemoration projects that range everything. Some survivors actually got together and burned down the schools they were incarcerated in. Some survivors got together and raised money to restore the schools so that they could be education projects. An apology, as we heard yesterday, and I thought it was a wonderful discussion, and two reparations processes that together awarded billions, probably about between 4 and 5 billion in reparations, individual compensation. And that was all sparked by private law, and it never would have happened without it.
This is interesting, thank you. The residential school example that you mentioned is illuminating, as it shows us how forgotten or silenced victims can turn to private law to open up a public discussion that the government and the public at large prefers to forget. Actually, if we turn our look to Israel, we have witnessed a similar attempts in Israel by families of Yemenite children who have turned to private law litigation about their children who disappeared in the 1950s, and several commissions of inquiry refused to acknowledge the responsibility of the state, let alone provide adequate compensation. But you also mentioned in what you just said that the trigger in Canada was the staggering rate of cases, and that the government preferred a settlement that included truth commission, apology, reparation, but it's still a settlement over litigation. So I would like you to maybe expand on the dilemmas involved in relation to the priority given in private law litigation in general towards settlement, and what are the dilemmas involved by it?
Yes, I mean, this is something I think, again, I found your book, Holocaust Corporations and the Law, really, really interesting on this, because you talked about the morality of settlement. And I was looking at your book again last night, actually, as I was just thinking about what I wanted to say today. And I think one of the points that you make really powerfully that has been very evident here and elsewhere is that settlement is a moment of legal creativity in a certain way. And so when you, the topic of this conference, procedures and processes, I think that private law litigation settlement enables parties to, and forces them, it both forces and enables, but it enables them to create processes that they never could have created in other ways. And just again, to use a couple of examples, in the residential schools example, the first priority of the National Indigenous Peoples Organization, the Assembly of First Nations, was a truth commission. So they, Phil Fontaine, the lead negotiator, he watched what was happening in South Africa and he said, we need to know. But they also looked at South Africa and said, it's a different situation. You know, these are very, very different. We had a reparations regime that went alongside. And so they modified the commission in very, very important ways. They created archives and history projects, again, inspired by what came out of the Holocaust litigation. And so there's been a massive effort that has come out, and a lot of, I would say, legal creativity. So, you know, private law is constrained in many ways, but settlement opens the door to find ways to respond that are more open than law, but that still have process, discipline, and other kinds of connections to law. So I think that settlement is often maligned, as you point out, because it doesn't create law in a certain sense. But I feel that view is falling by the wayside, because so many important developments have come out of some of these very, very, very significant settlements.
So let me push you a little bit about it. Let's think about a recent settlement that was just signed between Germany and the government of Namibia. Over the recognition of a genocide, but the creativity there was also reminiscent of some of the objections we saw in the Holocaust litigation from the German industry backed by the government, that there they phrased it as humanitarian aid as opposed to compensation or legal precedent. And in Namibia and Germany now, we hear about development as opposed to compensation. So maybe present to us a little bit the dark side of, or even not the dark side, but the problems with settlement and what we see in today's famous litigations.
Yes, it's a very good question. And I've been thinking about the Namibia settlement and some of the differences with the residential school settlement. And it's very interesting because, as you pointed out,
maybe give a few words on this, because maybe our audience don't know much about
right.
the settlement.
Yes, exactly. So in the Namibian case, the German government signed with the Namibian government. So this is quite important. And what they, as Leora said, most of the funding is to go to development projects and a much smaller fund that supports survivors in a more sort of humanitarian manner. And this is being sort of hailed and for significant reasons, because Germany is recognizing much more than it had the terrible genocide that was committed in Namibia. However, it's very interesting that the descendants of the survivors were not directly involved. It was a government-to-government negotiation, and the descendants of the survivors were not involved. And the descendants of the survivors are now raising very, very critical points about the very fact that there are not reparations, that development aid is a continuation of a patronizing attitude, whereas reparations is a recognition. I think in a way what they're trying to say is it's a recognition of a wrong, and it puts the survivors in a position of equality. We're not getting aid, we are demanding justice. And the survivors that have been very critical of the agreement are actually point to the Holocaust. And they say, in the case of the Holocaust, reparations were extended, and that is a critically important example. And so it's interesting, there's a lot of controversy around it. If I can take us back to private law, in Canada's case, as I mentioned, the Assembly of First Nations was a key voice in the settlement discussions, not just as a matter of giving them a seat at the table. They were part of a national class action. So they united all of these cases together in a national class action in order to get not just a seat, but a critically important voice at the table, so that the survivors' voices were essential to the negotiations.
This is interesting because you are looking not only at the creativity of settlement, but how the tool of class action can allow us to recognize the group of survivors or the group of victims and their families as distinct from a state. And we see here that a lot of time, and we know it for many years, but in Israel and the reparation agreement with Germany and the many and survivors that say that Israel is in a conflict of interest, and Israel never took on to represent the survivors. Israel represents itself, right? And if it would sue Germany, it would maybe lose security aid and so forth. So it's difficult for us under an international framework that only recognizes individuals and states to see the need to recognize a community of victims distinct from the state. And we can think about private law, whether it allows us to see it. First of all, you in order to have a criminal case, you have to rely on the state. And in the ICC, of course, you have to get through the prosecutor. Here, it's private litigation. So we can begin to think of this as something that maybe help us have transitional justice bottom up, or allow the group to articulate its wants as opposed to what the state wants. So maybe you want to expand a little bit about it, or tell us more about those who represent in private litigation, which are the private lawyers. So
yes, absolutely. And I do think that that's one of the real powers of private law litigation, is that survivors they can do more than ask to be heard. They can demand, they can insist. And private law actions enable survivors to speak in their own voices. And so that is incredibly important. And certainly in many, many situations, but I'll just, because we're discussing the residential schools agreement, as I say, that agreement came about in the shape that it did because survivors were, and they had to agree or there would be no settlement. I mean, it's basically that simple, right? And so that made a huge difference. At the same time, it's messy. I think I mentioned that there were 72 parties to the agreement. It will be no surprise to the people involved in this conference that survivors are not a homogenous group, that they don't necessarily agree with each other, just like all other groups. And so, so private law litigation is messy. The other things I thought, Leora, I might just jump to talk a little bit about what I saw some of the challenges being in that respect. And one of the most troubling ones is that private law is not possible without private lawyers. Right. And so private lawyers are both, I think, the heroes and also the villains of these reparations stories. In many cases, without the efforts of lawyers who were very, very concerned about the human rights issues and who often worked for huge amounts of time with almost no or almost no pay. These issues never get on the table, often without the efforts of people like that. And so they're, in that respect, they're incredibly important, and they make visible these human rights issues and people's voices that could not otherwise be heard. At the same time, and I think you see this time after time, the dependence on lawyers and the risk of self-dealing and corruption with lawyers is extremely kind of prevalent issue with class actions. And in Canada's case, in the residential schools agreement, the two voices at the table that were extremely important in settlement on the claimant side, one was the Indigenous organizations, the other was the claimant's lawyers. And the most unscrupulous lawyers signed up the most claimants in a very, very determined and deliberate way. And no surprise, they had the loudest voice at the table, besides the Assembly of First Nations, in terms of what some of the issues and processes would look like. And perhaps it's not surprising that to some degree, they designed a reparations process that did give survivors many benefits, but was also extremely beneficial for lawyers. One lawyer, I'll just mention him, his name is Tony Merchant, if you can believe it. I didn't make that up. One of the other really bad lawyers was called David Blott. So Blott and Merchant, but together they represented tens of thousands of survivors in this process. And so while most of the lawyers were really good, many of the survivors were actually represented by the lawyers that were the most unscrupulous. And Tony Merchant was described, and I think rightly, as being the residential schools agreement's largest winner because of the amount of money that he took away. So, you know, it's very much a double-edged sword in many, many respects. And the one I feel most complicated about is the role of lawyers. And I'm actually dealing with a case with the Law Society of BC right now involving really serious concerns about exploitation of survivors.
Thank you. I think we are coming to the end of the first round of the conversation, but I think that we didn't discuss one issue that's important for me, which is the way private law structure the issues that are being raised. What are the harms that can be discussed in private law and what is left outside. Maybe you can tell us something about this and what are maybe the limits that we can get through a private law discussion.
Yes, thank you. I'm a bit more of an optimist about private law on this than many people are, just like I am about settlement. And so I do believe that there's a lot of creativity and a lot of space and normative space in private law. But at the same time, there is no doubt that part of the real power of private law is its sharp focus on some very, very central, long recognized human interests, physical integrity being prime among them, and property, of course, also being very, very critical. And so I think what one of the challenges of some of the transitional justice style kind of reparations litigation is that survivors need to channel all the wrongs of history through the narrow doors of private law. And again, if I go back to the residential schools example, I think it's a good example because the initial wrongs that pushed that door open were sexual violence, sexual abuse of children, physical violence, and those were the cases that forced courts to listen. But survivors felt just as strongly, if not more, that being ripped away from their families without consent, that being punished for speaking their languages, that being punished for practicing Native spirituality, that those cultural, collective wrongs and injuries were just as important. And so it was very hard to render those in private law. I think it's kind of tiptoeing in that direction. But what was interesting, it goes back to the question about the creativity of settlement. One of the things that was, one of the reparations schemes that was agreed upon in the settlement discussions was a payment called the Common Experience Payment. And that payment was given to every single child who attended a residential school. And it was a significant amount. It was between $10,000 and $30,000. And that really was to recognize that every child who was taken was wronged, regardless of whether they suffered sexual abuse, physical abuse, etc. And so I think that was in a way of compensating for the narrowness of private law in the space that settlement allowed.
Yes, so I can repeat and summarize of what we conclude here, of what we just heard, that we can look at private law as a double-edged sword. On the one hand, it raises public attention, it gives voice, it empowers forgotten victims, and it leads to truth commissions, archival activism, and the like. But on the other hand, it tends to address physical and sexual harms. It is ill-fit to address intangible harms, and even more so, structural problems. I remember in the past we talk about only the harm to these families, but the structure of the residential school was meant to get a lot of land to the government to break up families, and in this way, and this is not being talked at all in this Truth Commission. And the ongoing position of these victims and these people, how do we deal with ongoing discrimination towards these people? So we see that even though private law allows us to open up some space, it also, it's very difficult to get to the structure and to reform the law and the institutions without political regime change. So maybe now we can open up the discussion to other questions. And I have here a question. First of all, I encourage you all to now write your questions, but I received privately one question already, and this is from Rachel Klaxborn, and she writes that recently, following the discovery of the remains of the 215 residential school students, a request by Canadian lawyers has been filed with the ICC prosecutor to open up a preliminary investigation. According to at least one commentator, it reflects the frustration that many Canadians feel with the slow uptake and follow through of the recommendations made by the Truth and Reconciliation Commission in 2015. So the request to the ICC, what do you think about it? Do we need international criminal law as a leverage or as complementing the private law? Maybe just reflect about this need to bring in the ICC.
Yes, thank you. And I think it's a wonderful question. And the question, as you know, there was an unmarked grave, and I think it's been mentioned earlier in this conference, discovered involving many children. And I think not for people like me that have been involved for a long time, but for many Canadians, this was a moment of horrific revelation in terms of just what the residential schools system was really all about. You know, when I first started dealing with this issue, people talked about a few bad apples in residential schools. And so this represents, I think, a dramatic shift. And there has been, as the question refers to, there has been a lot of frustration, and rightly so. The Truth Commission sat for many years. It issued 94 calls to action. And those calls to action went far, far beyond the residential schools issue per se. It talked about, adopting international documents and concluding treaties and the very distributive things you've mentioned, Leora. And so I do think that people are, advocates are looking for levers. And Canada, under our current government, we like to think we're a good actor in the international sphere. And so I'm not surprised that the ICC would be invoked in this circumstance. I think it's part of a more general campaign that's going on right now in our country to say, you better step up. And it's interesting, it has put a lot of pressure on the government, the discovery of these bodies, even though most of us knew that something like this was likely. The tangibility of it and the horror of it alters the discourse and the public sense of it. One example that I think listeners might find interesting, I believe it was just yesterday that the Minister of Indigenous Affairs announced that the federal government was going to make it easier for Indigenous people to reclaim their Indigenous names. Their Indigenous names were taken away. Children were actually given numbers, like most of the survivors I know remember their numbers. But the federal government has just said it will drop the cost, it will eliminate the cost, and it will expedite the process so that people can recover their Indigenous names as part of that very cultural and collective effort to restore what was destroyed.
Thank you. I see that Limor Yehuda has raised her hand, and maybe Limor, you want to open your camera and ask.
Hi, Leora. Hi. That was really fascinating conversation. So thank you for that. I had few comments, but since I look at the time, I will have only one, which is more of a comment or maybe a question to you. You're making a stark distinction between, the paradigmatic cases of transitional justice like South Africa or South America that we had, and changes or transitions within established democracies. And you mentioned that the reason that you see the difference is because this is like it's not something that had changed. And so I'm questioning that, because also in South Africa and in Northern Ireland, in other places that we will do regard them as the classical transitional justice, it's ours as well. So maybe it's an hour that did not reach to the new truth, but there is a segment in society that's still a significant segment that still sees. So I wonder about that.
Yeah, it's a wonderful question, and I think you're absolutely right. I guess the point that I was trying to make is that the political institutions have a little bit more comfortable distance from the issues than in the case of regime change than they do when, in our case, it's the same Canadian government that did this that is now trying to address it. But I think your point is absolutely right, and that the larger scale, the society as a whole owns these things, and that is a very, very challenging fact that is in common between many of these situations. And I think that that's the very reason that in established democracies, we reach for the same kinds of institutions to try to say, not what did they do, what did we do, right? What did we do? And one of the really interesting things in Canada, I think I mentioned this maybe on the first day in the chat, but Canadians never thought of ourselves as settlers. I mean, it just never occurred to us. The term never occurred. I mean, we might have thought settlers were the people that came in the boats, 200 years ago, but we never thought of ourselves as settlers, and that has changed. Now, admittedly, I'm in the academy, and that's a different world. But, now I hear students and professors we talk about ourselves. Well, I'm a settler. And that would have been unimaginable even 10 years ago. It's a long, long way, though, as Leora's question suggested. It's a long way from actually rectifying and trying to find a way to learn to live together and to rectify what we've done. But it's an unbelievable shift in self-understanding.
Thank you. I think that you brought the word settlers, which is a very important word in Israel. And the comparison is really painful to see how we are not only not changing the language, but also have memory laws now and things that we cannot mention. So it's we are still have a very long way to go. But I think that our session has come to its end, and I don't see other questions. So I wanted to thank you for an illuminating conversation, for me at least, as always. And I'm looking forward to the next session, which is going to be the continuation of this, because it's going to deal with private actors. So this session is going to begin in 15 minutes. It is going to be 5 o'clock in the afternoon in Israel and something else around the world, and you're all invited. So thank you, Mayo, and thank you, everyone. And
thank you so much. Thank you. I really enjoyed it. It was wonderful.
Me too.
Thank you.
So hello, everybody, and welcome back to the third day of our conference, The Scripts and Settings of Transitional Justice. My name is Dr. Inat Albin, and I'm the Academic Director of the Minerva Center. I very much enjoyed all conversations up until now, and I look forward to this panel that I'm chairing, because in this session, we have two very, very interesting papers, which I have the privilege to read before, on private actors that are involved in traditional justice. One of the actors that is discussed is philanthropic bodies and organizations, and the second is the theater, or more precisely, legal doc performances. I think that both papers raise some very interesting shared questions regarding the role of these private actors in relations to traditional justice. And from my perspective, as a lawyer, it also raises many considerations of whether they should have some legal obligations or responsibility as private actors that are very much involved in transitional justice. In the previous discussion between Professor Bilski and Professor Moran, we talked about the strength and the limitations of private law. But in this panel, we come from a different starting point about private actors, because the baseline is that their work or activities should not necessarily be at all regulated, that there should not necessarily be any involvement in their activities because it is based on an agreement that their autonomy should be preserved, an autonomy of philanthropic actors because of their property rights and their choice to donate or to bring their money and resources to whichever goal they wish to promote, and the autonomy and the free expression of actors and arts. And I think that within this setting, we actually take the discussion held in the previous session a step further and trigger many of the issues that are very relevant to the discussions we hold in this wonderful conference. So I'll start by introducing our speakers. The first speaker is going to be Julia Anasteva. Julia is a research fellow and a PhD candidate at the Max Planck Institute for Comparative Public Law and International Law, Heidelberg, Germany. She obtained her LLM in International Human Rights Law at the University of Notre Dame Law School, MA in Human Rights and Democratization in the Global Campus of Human Rights Regional Program in Cascais, and the LLB at the American University of Central Asia. While pursuing her first degree, she was an intern at different national courts, including the Constitutional Chamber of the Kyrgyz Republic. After graduation, Ms. Anasteva started her duties as a teaching and research assistant at the law faculty of the AUCA while working with the American Bar Association, and she will present her paper on the role of private actors in transitional justice processes, focusing on philanthropy. Our second speaker is Ms. Shlomit Cohen-Scally. Ms. Shlomit Cohen-Scally is a dramaturge, if I'm pronouncing it correctly. She's a doctoral student in the Department of Theater Arts at Tel Aviv University. Her doctoral dissertation investigates the legal docu-theater in Israel. Dramaturge of the Theatron ensemble operating at the Khan Theater in Jerusalem. And for more than a decade, she worked as a dramaturge and co-director in the theater workshop at the Faculty of Law at the Hebrew University of Jerusalem, our university and faculty. Julia, the floor is yours, and we're looking forward to your discussion.
Thank you so much. Thanks a lot for this generous introduction. And first of all, I would like to thank the both Neva Centers for organizing this conference and inviting me and giving me the opportunity to share some parts of my research. So today I'm going to present my paper, which I wrote about the private actors' involvement in transitional justice processes. I will start from explaining what types of actors and assistants I'm looking at in my paper, and then I will move to some examples. I will briefly discuss a few cases that I'm looking at in my paper. I will move then to some concerns that might exist with relation to this private assistance to transitional justice, and then I will end with some international legal analysis, and in particular, I will be speaking about privatization and accountability. So first, the types of actors I'm looking at, it's not only philanthropies, but also privately sponsored NGOs, mostly actually by these philanthropies, and also businesses, corporations and multinationals. And the types of assistance I'm researching are non-state financial and other contributions, provision of resourceful aid, meaning like, for instance, technology to logistics and expertise. And finally, privatization, meaning when a transitional justice mechanism was privatized by a private actor or outsourced by international organization or a state. So very short, the main goal of my paper is to make non-state contributions to transitional justice a more visible object for scholarly scrutiny. So starting from examples, starting from the criminal justice pillar. So for instance, extraordinary chambers in the courts of Cambodia and special court for Sierra Leone were sponsored by various philanthropies like Open Society Foundation, Ford Foundation, Rockefeller Foundation, and so on and so forth. These foundations not only gave money to these tribunals, but also provided consultants and an expert to finalize some of their reports. The tribunals were also accepting money from private corporations, like, for instance, Microsoft. Another rather unconventional example is the Papua New Guinean Ad Hoc Tribunal. And this tribunal was a part of a framework of remediation initiative developed by the Barrick Gold Corporation and the Porgera joint ventures as a response to human rights abuses, including sexual violence in the country, in Papua New Guinea, and in particular on the territory of the Porgera mine. So the troubling issue here in this procedure is that if a claimant agrees with the provided reparation package, which might include monetary compensation, psychological help, education, training, and so on and so forth, she will not engage in any litigation against Porgera or Barrick. So strong doubts arise about the appropriacy of such mechanism. The fact that a company investigates, assesses evidence, and awards reparations makes a company simultaneously the judge and the executor for its own wrongdoings. Another example is the Commission of International Justice and Accountability. It is a private non-profit organization registered in the Netherlands, and it devotes itself to establishing the individual criminal responsibility of perpetrators in conflict and post-conflict areas. So one of the most known works of the results of their work is the smuggled documents, a nearly 1 million page document from Syria. And these documents were heavily used for building universal jurisdiction cases, and including the one in Germany, the Koblenz trial, which is pending right now. Some of the CJUS employees stress that it's crucial for the organization to build its brand and to post a unique body acting in the field of private investigations of mass atrocities, because they need to sustain on the justice market and continue receiving money from their donors. An interesting example from the reparations pillar is the ICC's Trust Fund for Victims. The fund accepts money from states, international organizations, corporations, and individuals. So interestingly enough, private donors, unlike public ones, have an option to allocate funds for specific project of the trust fund. So the fact that they can do that can mean that the fund, as well as the ICC, recognize that private donors might have their own priorities in reparation programs, and this contribution is actually hard to subsume under anything resembling a responsibility model. So moving to the problems that might arise in relation to this private assistance. First, donors and philanthropies have no market accountability. They earmark to other organizations or states which cannot unelect them or stop buying their services in case they do not share their views on their grant-making decisions, because who bites the hand that feeds? And businesses are also not empowered and even designed to perform public services like the administration of justice. Moreover, the secrecy of the amount of donations and of their destination, as well as non-disclosure of compensation of private contractors who administered transitional justice mechanisms, can open gates for corruption, since the public sector is not able to subject the process to public scrutiny or compare it to other projects that happened in other countries, for instance. Also, private entities are not structured to tackle the underlying structures that led to gross human rights violations, as was mentioned during our previous panel. And the victims have to be redressed and perpetrators have to be brought to account. It cannot be done by a private actor simply because the obligations to do that are not imposed on them by international law. They are imposed on states. So Philip Alston, for instance, once said that philanthropic giving is not a democratic and transparent process, and all decisions on replacing the government are taken behind closed doors, and where they can easily convert their economic power into political power. The last point is on legitimacy, just a few words. So the practice of earmarking donations for certain operations and the presence of conflict of interest could undermine public confidence in transitional justice mechanisms. Some empirical studies of the legitimacy of NGOs in post-conflict areas show that when an NGO is privately sponsored, it loses the legitimacy of the local population and civil society, because people are starting start to think that there are some interests involved and the profit interest involved. So this problem can also exist. So during my research, I quickly realized that there is not much on the international level what could regulate various types of donations. And then I decided to look at whether international law can regulate at least transitional justice outsourcing. So as you might imagine, the standard notion of privatization will not always apply to the scenarios I just discussed, because private actors sometimes just decide to assist a state or international organization by providing expertise, money, or technical assistance, and so forth, without the state's clear consent or a clear or official request for doing that. So in this example, such actors do not take over transitional justice, but rather provide additional services which are also of public nature. And I call this scenario, when it's unclear whether a state gave its consent or not, implicit privatization. But the main question remains, is privatization of transitional justice allowed under international law? For instance, the privatization in areas of human rights and justice has been encouraged by the UN 2030 Agenda for Sustainable Development, where public-private partnerships are key actors in realization of these goals, including justice and peace. So, digging deeper, I realized that international law is mostly silent on that issues. So, for instance, the Committee on the Economic and Social and Cultural Rights made clear at the outset of the general comment that privatization is neither in violation nor in compliance with the international framework for economic, social and cultural rights. So that is to say, the lege ferenda international law is not, or it cannot prohibit or limit a state to enter into public-private agreements with private actors, even in administrating and designing the justice mechanisms. But in my paper, I'm trying to show that there are certain functions that cannot be outsourced or outsourced only under strict conditions. And I call them inherently sovereign functions. And this approach that was actually developed by several international lawyers and scholars, this approach could actually help critically looking at privatization, not only when a violation happens, but also when we will be willing to mitigate negative consequences of the private involvement in transitional justice. So I also argue in the paper that there is a pressing need for regulating the private involvement in transitional justice processes in international law. So as the law stands now, both articles on the responsibility of states for internationally wrongful acts and the Maastricht principles for on extraterritorial obligations of states in the area of economic, social, and cultural rights, they provide only for the state responsibility, even for the actions of private actors who were empowered by the state to exercise elements of governmental authority. So we have some rules, but still, again, the responsibility will be returned back to the state. And yet the claim of my article is that we need to make international law relevant to the nature of contemporary practices organizing, administrating, and running transitional justice processes. So these practices shall defy traditional patterns of causality that directly links a violator with a violation of or conduct, and this scheme can be attributed to a wider number of public and private actors. So I advocate for the new logic of attributing responsibility and offer an alternative responsibility model, which is based on the proposition of Margot Solomon, who says that responsibility for violations of a systematic or structural nature may be attributed not on the basis of conduct or establishment of a direct causal relationship, but on the basis of the failure to carry out due diligence and conform the standards of care. So she adds that responsibility should be assessed by 4 criteria. These are emergence of the problem, then control of relative power that gives the actor influence over the direction of finance, trade, and development, the capability to assist, and interest or benefit derived from the existing distribution of global wealth and resources. So the existence or construction of accountability structures for multiple duty bearers is crucial for right holders, such as victims of gross human rights violations who might not be visible when their rights are breached. So the last, my last point is that the need for international regulations and monitoring mechanisms for private donors' behavior is necessary, because without effective system for making private donors responsible, it is challenging to point out where their performance might be improved or their responsibilities strengthened in the interest of victim societies. And I thank you all very much for your attention, and I'm looking to the Q&A session, and I look forward to hear what you think about my project. Thank you so much.
Thank you so much, Julia. It was illuminating, and I already received several questions. So I encourage everybody, this is a good time to, before we move to Shlomit, to remind you that you can ask questions using the Q&A, and participants can send me also questions on the chat. So thanks a lot. And now we'll turn to Shlomit Cohen-Scali. Shlomit.
Hello. So first, thank you for having me here. Coming from the theater, I'm an outsider, a bit of an outsider here, but these few days and fascinating presentations really convinced me once again about the dialogue that these two domains, the law and the theater, can and should create, and I'm very happy to take part in it. I will start, and then after a few minutes, I will share screen with my presentation. The theater, and documentary theater in particular, provides a highly effective setting for advancing process of social change and social justice. Documentary theater illuminates areas we have so far chosen not to look at and uses its performativity as a means of correction. The performance allows the audience to identify with those who up to that point were merely perceived as the other and bring them to life. The informality of the theater and its being a liminal space, anchored in reality on the one hand, but enjoying artistic freedom on the other, allows it to move between a variety of languages, times, perspective, and means of representation. I will focus on the special type of documentary performances, legal docu performances. I will examine the means by which they raise awareness of the need for process of transitional or restorative justice. I will not always respect the distinction between those, and take part in bringing them about. Legal docu performances are unique in this context because they do not emerge from the event as it took place in reality, but from its reconstruction in the courtroom. Thus, in addition to responding to the actual event, the performance focuses our attention to the ways in which the event was represented, reframed, interpreted, and finally decided in the court, the embodiment of legal establishment. Transitional justice sets off from the recognition of social or historical injustice and is centered on the responsibility of the regime for this injustice. By contrast, my point of departure is a legal system, arguing that a necessary step towards transformation is a recognition of the public that the legal system itself is not neutral, that it had a significant role in creating justice. Now, let me please share screen, and it would be a low-tech technology now after you, Julia, very, just a moment. No, sorry. Okay. Legal docu performances recreate the legal event in whole or in part on stage, transfer it to an aesthetic sphere, and give a role to the audience. I will show how by these means legal docu performances transfer responsibility to the audience and demand its recognition and involvement in the required change. In this way, these performances provide yet another stage for the performance of transitional justice. To substantiate these claims, I use illustrations from two domains that call for change: the legal handling of sexual crimes and the Yamenet kidnapping affair. Theatrical reconstructions of legal cases, including events consisting in the reading, Theatrical reconstructions of legal cases, including events consisting in the reading of court records of such cases, invite us to listen again, and yet in a new way, to the legal procedure. In so doing, they awaken our critical senses. These performances do not seek to glorify the past and reenact it. Rather, they investigate the course of events and submit it to a series of questions. Was it just? Was it necessary? Could or should part of it be avoided? Could it have been acted upon differently? Much like psychological reenactment, the processing of the trauma is a lever of change and liberation. Furthermore, I have stressed that the reconstruction is not of an event out there in reality, but of an event in the courtroom. There is a subtle allusion here to the reconstruction of a crime, which takes the criminal back to the location of the crime. By reconstructing the legal hearing of the incident and not the incident itself, the performance defines the courtroom at the crime scene and obliges us to examine the moves made by the court, its bias and interest, thereby questioning the decision and its justification. An example of the difference between spectator sensibilities and the very different mode of observing and hearing in the theater and the courtroom can be found in the theatrical reading of the proceeding from Darin Tatour's trial. At various moments of the very minimalistic reconstruction of the interrogation of the witness, the audience responds with bursts of laughter. It is highly doubtful whether such a reaction occurred at the corresponding moments in the in the court, and it's no doubt at all as to how it would have been received had it occurred. These little moments point to the enormous difference between the two contexts and the respective framings. The same is true in Demonstrate and in Water Have Mercy on Me, two performances that seek to increase awareness of the inadequacy of the legal process and handle sexual assault. Both works use a proceeding of the same rape trial. Demonstrate uses only the transcription of the trial, and Water Have Mercy on Me alongside other three texts. To understand these works, we should remember that in the course of the 2008 trial, the girl was requested to demonstrate the posture in which she was raped, a request that stirred a considerable amount of public denigration. Aware of this request, the audience entering the theater, whether critical or only curious, already has some expectations. The recreation of the trial and Demonstrate does indeed fulfill our expectations. The defense lawyer is aggressive, both in addressing the girl and when joking with the judges. The questions directed at the girl are embarrassing. What clothes she had on, how they were taken off, what exactly penetrated her body and in what posture, what was a general understanding of various forms of sexual conduct, and so on. The request to demonstrate the epics of this investigation only reaffirms the outrageous insensitivity of the court to the girl and her ordeal. Here, the very reconstruction does a critical work. But legal DOCO performances can do more than merely recreate the event. The transfer to the theater hall relocates the event, situating it in an aesthetic sphere. Even when the performance uses the records of the legal hearing, it enjoys considerable freedom in choosing its means of representation. Thus, in Demonstrate, despite adhering to the written text of the court report, the artistic choices emphasize the critical dimension of the performance. In order to highlight the absurdity of the situation where a young girl, the victim, is investigated and judged by 5 older men, Dilberg, the director, chose to switch the sexes. 5 women play the role of judges and lawyers, while the girl is represented by a young man. At the same time, the original language of the trial is retained. In Hebrew, there's a difference between masculine and feminine in the language itself. The woman uses masculine grammar, the man using the feminine. This maneuver generates estrangement, resulting in a more intent and less automatic grasp of the dialogue and of gender inequality in general. The girl is isolated, placed on her own at the far end of the hall, at the distance she would have to cross in order to speak and make her case. The distance is further accentuated by 3 video cameras consistently broadcasting fragmented close-up of the girl. He's an actor, as you remember. Her broken image calls to mind the trauma she has experienced, as well as the difficulty in the face of so many legal stratagems and distractions to get at the whole truth. The screens also symbolize the picking, both at trial and on stage. And the forced performativity manifests so brutally in the demonstration. In Water Have Mercy on Me, the displacement to another space is even more significant. While in Demonstrate, we are given a representation of the courtroom, in Water Have Mercy on Me, Buenos takes us out to the town square. The performance takes place in the fountain area of Bloomfield Park, opposite the old city of Jerusalem. The opening image looks pastoral. The fountain, the water ripples, the actresses all join in creating the pastoral scene visible to the entering spectators. At once, the scene is shattered and we are thrown into another one. We understand that we witnessed a rape trial. Furthermore, there is no separation between the various legal figures, but only between the complainant and the figures representing the system. The legal system in its entirety is portrayed here as insensitive and offensive. From a legal point of view, it matters a lot whether it is a defense attorney who is supposed to protect his client who is harsh with a girl, or whether it is a judge treating her insensitively. The performance does not respect this distinction. Harm is harm is harm. According to Barn, to succeed in generating a public debate, the theater must overcome the following difficulty. In most shows, the viewer understands the emotion portrayed on stage, but does not feel the emotion. The viewer can grasp that the character is afraid, but she herself does not feel in danger. Water Have Mercy on Me, however, manages to evoke this immediate feeling in the audience. To mention but one example, the timing of the performance is such that when, in the drama, the violated woman is left outdoors alone in the dark, the actual evening falls, and the viewers too find themselves in darkness. The fact that it is not a manipulation of lightning, but real darkness, make all the difference to our involvement. May God Comfort You, another work by Maya Buenos, and Maternity by Hannah Vazana Greenwald, both dealing with the Yemeni and Balkan children affair, are further examples of the advantage of the aesthetic sphere. These two documentary performances weave together records of the Commission of Inquiry that investigated the allegations of child abduction, natives of the Yemen and Balkan in the 1950s. And as Liora mentioned before, the Commission dismissed the allegations. Interestingly, they consist mirror images of one another and highlight two complementary aspects of the story. Maternity centers on the birth experience. One of its highlights is the shattering gesture of the mother who had just given birth, reaching out to receive her baby, but being left empty-handed. Her hands, still hanging in the air, waiting for the baby that was taken from her, continue to haunt us, a symbol of the piercing pain that underlies this affair. Buenos in May God Comfort You chose the opposite moment, using the mourning ceremony of sitting Shiv'ah as a framework for the documentary materials. The actors ask us to recite a blessing for erased son of erased, Machuk ben Machuk, making the disappearance of identity absolutely conceptuous and concrete, and making us, the audience, share the responsibility for the eraser by agreeing to have the names and persons behind them deleted. Both performances highlight the emotional aspect of the affair, inducing us, the viewers, to take part in the processing of a trauma, the trauma of the individuals who were affected, as well as our collective trauma as a society whose norms and practices allowed and perhaps still allow such cruel reality. In May God Comfort You, the music, which is initially played with Yemeni instruments and sung to the rhythm and Yemeni accent, is gradually undergoing a distinct process of erasure and transformation to a more Israeli, Ashkenazi, Givatron style music. The costumes, which likewise begin with a traditional Yemeni costume, are thrown off the figures, leaving them in a pioneering Israeli attire. The characters internalize this process and eventually continue the process of adaptation, thus reinforcing the sense of submission to power. The use in both instances of cultural treasures of a culture that has not been valued, that has not been recognized as a culture, to the point of legitimizing child abduction, is not merely a dramatic tool. It gives validity to stories that cultural erasure has muted, using traditions in custom and jewelry, musical instruments, and original liturgy, all evoking memory and emotion, is of course a privilege of the theatrical event. They are not admissible evidence in court, but are highly effective in bringing about acknowledgement and rehabilitation, as was noted yesterday regarding public apologies. The performance triggers empathy and identification with a particular story, but it also emphasizes that we are talking about widespread social phenomenon, that this story is but one of the many that could have been chosen in its stead. Ligadoka performances often use the device of giving a role to the audience. The role may change in the course of the performance, moving the audience from its passive position as witness to that of a judge who is obliged to take a decision, and finally, even to that of a defendant who stands to trial. The transition between the different points of view deepens our understanding of the event. The audience place as witness and judge is relatively intuitive, deriving from the very nature of the event. More thought-provoking and important, however, is the attempt to place the audience on the side of the offender, responsible to some extent for the injustice that the performance criticizes. Granted, the theater cannot administer punishment and create accountability, but it can make us realize that it is a public lack of response that allows the prevalence of evil. Aesthetic design of the event by means of what Hans Stitt calls aesthetic of responsibility seeks to awaken the audience response ability. As Tracy David noted, time in theater is a performative time, a time that can encapsulate past, present, and future. Recreating the past can enable us to change the future. In May God Comfort You, Buenos uses this bubbling performative time to criticize the present as harshly as possible. In the final monologue of the performance, Buenos turns, without any introduction or preparation, to an affair from present-day Israeli reality, not a forlorn historical event, not archival materials leaking from old boxes, but a live, here and now episode, the Depo-Provera affair, the giving of birth control treatment to Ethiopian women without their consent or knowledge. The connection between the ordeal of the Yemeni children and the Ethiopian affair points a finger of blame to the audience who can no longer hide behind history. It's we ourselves, not our parents or grandparents, who turned a blind eye and condoned an affair tainted with the same arrogance, racism, and discrimination as the previous Yamant affair. A remarkable changeover of the audience occurs in Demonstrate, at the very moment of the demonstration. Faithful to the original episode, the demonstration takes place on the floor of the courtroom. At this stage, the actor, the plaintiff, proceeds to the center of the space between her and the judges and kneels on the floor. As a result of the way the audience is seated, almost everyone has to stretch, bend, or otherwise change position in order to see the scene. Now, when we think of it, the play in fact puts the audience in the position of a defendant, accused of peeking, of turning injustice into a show, of taking the spectator position while leaving to others, the legal establishment in particular, the responsibility for our social norms and our public sphere. At this dramatic moment, all three settings, the crime, the courtroom, and the theater, are united in the gaze of the spectator, observed in the suffering and humiliation of the victim. The performance thus seeks to expose our violence as viewers and reduce the gap between what we thought to condemn and what we do ourselves. Activating the violence hidden within us may allow us to understand the depths of the flaw that the performance points to. The theater provides us with an opportunity to look directly at what is ugly and blameworthy, first and foremost, in ourselves. Legal docker performances take a clear stand on the power relations between the public and the legal system operating in it. It is the public who endows the system with its power. Without public consent or obedience, the system would lose its elevated status. The norms protected and enforced by the law should be a matter of public discourse, and rather than at least only legal discourse. The public, therefore, bears responsibility for injustice done in its name and the power it gives to the justice system. While the common notion that the court alone is to blame exempts public from responsibility, the performance surveyed here, and as well as others I didn't mention, remind the audience of its crucial role as a creator and propagator of norms. Legal docker performances do not purport to replace the legal system or the more formal process of transitional justice, but they seek to shift the center of gravity from legal discourse to public discourse. They alert us to the responsibility of each and every one of us and to the ancient biblical ideal of truth springing out from the earth. Emet me'eretz titzmach. Thank you.
Wonderful, wonderful. So again, thanks a lot. It was really, really fascinating. And I'll start with a few questions that were sent to me and that I have for you both. And I encourage, of course, more people to ask questions. So the first question goes to Julia. Professor Liora Bilski is asking whether you can draw a continuity from Holocaust litigation, where the German corporations funded their own historical commissions, opened their archives to them, and paid for the historians, and your work. And I want to add also questions for Julia. Your research is very much based, and I think the law also is based on a very strong dichotomy between the private and the public spheres. So while in international law we have responsibilities, of course, for states and for public actors, we don't have some same responsibilities for private actors that are involved, especially when we're talking about multiple actors that are involved in the process. But I'm wondering whether this distinction is generally still relevant in your view, and in what way? Because when we're talking about actors who have a direct impact or very strong connection to processes, procedures, and results, should we continue this historical distinction between private and public that is now very much embedded within legal doctrine and legal instruments further, especially given studies like yours that point out how much private actors are at times very, very impactful and very much connected to these processes. And this turns me to another question, and it is this very different when we're talking about transitional justice processes than other instances where these private actors are very much involved? The business community, philanthropy, NGOs, like for example, equality issues and stuff like that, that we know that philanthropy has a lot of impact on equality policies and other issues. Do you think that, again, we should draw any distinctions between these kinds of involvement? And in this respect, because I'm a labor lawyer, not a transitional justice person, I can share with you that there's a lot of research in labor law on what is called shared responsibility, even within the global, for example, supply chains or manufacturing that crosses countries and borders and involves multiple actors. And there in these pieces of studies, and also it was implemented in a few international policies, they pose obligations on multiple actors along the supply chain. And so that can be a very interesting, practice or tool of a box tool that you can look into, I think, that can be helpful for your work as well. And this actually takes me to Shlomit's work. And Shlomit's work, I think, is based on the assumption that, of course, performance has to be very free and performance has to act. And the levels that you talk about, the reconstruction of the legal event, displacement to another sphere, the role of the audience, it's all very much embedded in this, autonomous sphere of free speech and freedom of art. But where do we draw the line, for example, again, where performances have an impact, for example, on public opinion that can be very influential in comparison, for example, to an NGO, like For Mothers in the past, right? And their activities. And also art is many times funded also by private donations and private entities. So I would like to link your papers together in this sense, because I think they provide us with a very interesting spectrum of private actors that we can think about in relations to transitional justice and how we should address them. And I have here another question to Shlomit, and that is there a difference in the role of record theater in cases of transitional justice, like the Yemenite children, versus regular injustices, like rape trials? Can you say something about the special role of the theater in relation to TJ in non-transitional situations? And another question for Shlomit from Yurit Balas is, can we find similar effects, mobilizing emotions, public involvement in real trials, political other, and can we find dramaturgic practices in courts, not only on the stage? So a few out there. We'll start with Julia and then go to Shlomit. And if further people have questions, please write them down. Thank you.
Thank you so much for this very interesting questions. I will start first with Professor Bryski's question about the Holocaust litigation. I have to say that I'm not very familiar, like I'm not an expert in this particular period of time and in this particular period of transitional justice, if we can even name it like that. So that's why I will be very careful while giving my comments. But first, these litigations were against private companies who were engaged in violations of human rights, while my research focuses mostly on the actors that were not involved in violation of human rights, but rather are helping to promote justice and to implement it. So I guess that's the difference between, because now for this kind of scenarios like the Holocaust litigation, we have the business and human rights framework where we can somehow bring the private companies to account for violations of human rights. And if I understood correctly, you were asking about the historians that were paid, but I didn't understand, privately or still by the court.
So let me explain. It's just, it was a privatization of the role of the courts or the judges to find out the truth, or even historical commissions, because the corporations funded all of it, and appointed the historians and published the papers and opened their archives, which private actors don't have to. So it was an early privatization effort of part of the transitional justice, and in my book I think that it was a great thing. It was creative. It allowed to differentiate between the role of the judge and the role of historians. It allowed for better history, but there were limitations there. So I wanted to ask, but if you're not familiar, then
Yes, what a shame that I'm not familiar, because it seems like a perfect example for the argument I'm trying to make, that yes, and it's also linked to the discussion we had previously, we had an hour before, right? So I will definitely look into that, and will read your book with great interest, and then I will be happy to discuss, because I think you are in the place to tell me more rather than I can answer your questions. And then I'm pretty sure that that maybe I can even accommodate this example into my research and say that even truth commissions were privatized. Because in my paper, I found examples only when the truth commissions were sponsored by private actors, but not you know, run by private entities. I think it will be a great example.
And you would see also the benefits and the hybridities that Einat was talking about. So it will make your case more complicated, but maybe interesting.
Right. Okay. Thank you very much for your suggestion. Actually, that's why I'm here, is to hear new examples and to hear new ideas. So that's how I can enrich my own research. So thank you so much, Professor Brisky. And then to some questions by Nat. The first one about the public and private divide, and if I think that we should actually get rid of this divide. I personally would say yes, because as you rightly pointed out, private actors, they possess such a huge power. They're so impactful in our current world. So I guess, yes, international law has to pay more attention to what they do and to attach responsibility to their actions. But unfortunately, international law as it stands now does not allow us to actually get rid of this distinction, because private actors are not subjects of international law yet. But maybe like, you know, I think today is the anniversary of guiding principles on business and human rights. So maybe this kind of frameworks will actually help us one day to come to the point where private actors could one day become a subject of international law and state on the same foot with states and international organizations. I mean, in the sense of bringing them to responsibility under international law. And on the question of equality issues, actually philanthropies and other private actors, they are involved in various public issues, like the public health, right? The financing of WHO, financing of vaccination programs. That's all public services, including the equality issues and the local justice issues. And the one example that I bring in the paper is the memorialization program in the US in the aftermath of the Black Lives Matter movement. So yes, indeed, they are also engaged in this initiatives as well. But why I think transitional justice is a special case is because it's so sensitive. transitions happen in mostly in post-conflict societies or after dictatorial regimes. Yes, we know that transitions sometimes happen in already established democracies, like now in the US, but still, I think this processes are so sensitive, so that's why the additional attention should be paid for the behavior of private actors when they are involved in such processes. And I will definitely look into the shared responsibility and the labor law for sure. But maybe you also have heard about the new project by several scholars who drafted the guiding principles on shared responsibility, but between states and international organizations. And I guess that the same actually could be done to include private actors in that, especially private actors that are in partnerships with this public entities. So my accountability section of my paper is the most underdeveloped. So I have a lot of work to do, and all suggestions are very welcome. And yeah, I'm already looking forward to dig deeper into the examples you shared with me.
Thank you, Julia. That was great. Shlomit, yes.
Well, thank you for the very good questions. And I think that something that is interesting about theater is that it has a procedure of its own. So the independence of the process it has a very large freedom of speech and freedom of artistic measures, but there is a certain research that you need to do. And there is a certain procedure that you go through in doing a performance and bringing it about. That is not something, it's not like writing a post on Facebook. So it has this procedure that you go through, and I think that it cleans some of the effects that can be from all kinds of sources. But there is, of course, a distinction between fringe theater, which is more marginal, and the mainstream, the national theater. And I think that the sponsoring and the founding of those performances are very different according to their subject. And the question about the difference between traditional justice or other injustice, I think that you can find those performances in different stages, and they have different funding. And for example, Demonstrate, which has to do with sexual harassment and legal dealing with those cases, is funded by the Sal Tarbut and is assigned as a performance that students should see and that we should sponsor and open the ability to more and more audiences, rather than Maternity, which if they would try to perform, let's say, in Abima, they won't be answered by any chance. So there is a difference here. And also I think that in response to the procedure, it's interesting about Maternity and God will comfort you, that there are two independent performances. They didn't know on each other at all. But when you look on the images and the language that they brought to the stage, and they're in very nuanced decisions, there's something similar about it. And I think that it says something about the image that emerges from the case, and that you don't come with an idea. Sometimes you do, but then the process does something to this. You come with a certain ideology or certain truth about the things, but then the process makes you be more attentive to the nuances and the specific treatment that this case needs and to be handled with. And as for and another thing I think that is different between traditional justice performances is that they almost always have this conversations after the performance. And there's something very strong that happens there, because almost always there is someone that stands and says, this is the first time that I'm speaking about this. This is the first time that I'm feeling recognized. this is the first time that I want to go home and ask my mother about what had happened and this silent thing. And I think that in other areas that are more talked and are more present in our social and public sphere and debate, it happens in an easier way. And this moment is like, and just today I got a message from Hannah Vazana Greenveld about a performance that happened yesterday of maternity. And the light fell down in the middle of the electricity, fell down in the middle of the performance, and they were standing in silence, audience and performers. And she didn't know what to do, and she took her laptop, and it was a moment of hearing the testimonials of nurses. And she asked, she just put without any sound system, and they heard it in the darkness. And she said, she wrote, I understood the potential of this moment, and I asked the audience to take their cell phone and light the stage. And suddenly it was, she wrote, we were all taking action together in breaking the silence. And I think that in those performances, it's a bit more a stronger feeling. And a little remark about Irit's question. Of course, I think that those performances recognize that the performativity of the court, and it triggers it to bring it to stage and to say something about the way that it manipulates some of the proceeding. And of course, you know, Eichmann trial is very much discussed about this aspect. But I think we sometimes, the public, you know, not the law scholars, forget about this performativity and what it does. And we think about it in American law series, Law and Order and stuff like that, but we don't really think of the way demonstrate is exactly about that, about taking a performative and how you use it in this sense, in a bad way maybe, but of course there's others. It is a bit more investigated, I think, the performativity of the law.
Thanks so much. So if we were not Zooming right now, I'm sure everybody would have joined me in clapping for this wonderful panel. It was very, very interesting. And I think this is surely a discussion that we have to continue holding, because both of you just raised very contemporary and pressing issues that are related to transitional justice from two perspectives that at first seem very distinct, but we saw the links among them and the combination. So I thank you both. It was illuminating. And for our audience, we're going on a break now, and we'll resume for our final session of the conference at 6:15 Israeli time. So it's in 15 minutes. Thank you so much.
Thank you very much.
Thank you.
So I'm Limor Yehuda, and I'm a lecturer and a researcher of transitional justice with the Minerva Center for Human Rights. And I'm honored to be the chair of this eighth and last panel of this international conference, The Scripts and Settings of Transitional Justice. Our session is about criminal justice, jurisdiction, punishment, and their effects. We have 1 hour and 2 presentations and good amount of discussion. But as we are the last panel, the last session, I thought to save the last 5 minutes, not more than that, for a brief closure of this conference. So participants are invited to have a chance to say a word and thank you. But first things first. So we have. So I want to present you two, and I want actually to link it to the first presentation that we had in this conference. And we had started this conference 2 days ago, 3 days ago, with a keynote by Kevin John Heller who has talked about the Nuremberg trials as the first TJ program, and point to the need to find a balance between the goals and needs of the persecution and succeeding to bring a conviction, of course, a case and a conviction, and the goals of transitional justice, and which relate to the opinions of the more general public. And it seems that the two presentations that we're going to hear now are connected and can be seen as going to continue and complement this theme that that actually started our conversation in this conference. So our first speaker will be Dr. Patrick Labuda, and he will talk about relational complementarity. Patrick is a Swiss National Science Foundation postdoctoral fellow based at the University of Amsterdam. He's a lawyer and a historian by training and has experience in human rights and security sector reform. Most recently advised the European Union in Libya and was involved in reforms in several locations in Africa, including Sudan, South Sudan, and the Democratic Republic of Congo. His monograph on international criminal tribunals and domestic accountability is forthcoming by Oxford. Okay, and our next speaker, our second speaker, will be Dr. Mara Redlich-Revkin. And she will talk about how does punishment affect reintegration by using empirical evidence from ISIS, from Iraq. And Mara is the National Security Law Fellow at the Georgetown University Law Center. She is a political scientist and a legal scholar, specializing in empirical research, as we will see, on armed conflict, political violence, migration, peace building, and transitional justice, with a regional focus on the Middle East and particularly Iraq, where she has been conducting field research since 2015, both for her PhD dissertation on the Islamic State system of governments and as an advisor to several United Nations agencies working on post-conflict stabilization. So Patrick, you may start. You have 15 minutes. I'm collecting questions in the chat and in Q&A. And for participants, you may raise your hand if you have questions. So Patrick, the floor is yours. Thank you.
All right. Well, thank you so much, Limor, for the kind introduction. I actually didn't realize we were doing longer introductions, or else I would have sent you a bio, or a more complete bio. But thank you actually for mentioning the book, because I do draw in this presentation and in this paper on my book. I want to thank the organizers for the opportunity to be here. And what I will be doing is talking about an issue that I guess I've been thinking about for quite some time. By the way, yes, please give me a 3-minute warning so that I know when to wrap up, because I think I might go slightly over if I don't get that warning. So yeah, so essentially this paper really, the paper is part of a bigger project. And in my book, I really look at how complementarity operates in practice. And so what this paper is doing is sort of drilling down on specific issues, and it ties in with the conference theme in that I draw out distinctions between law and policy, substance and process, and outcomes and procedures, and some of this will be apparent in today's presentation. And so I developed a theory of what I call relational complementarity. So that's really the pitch. I won't discuss the entire theory in this paper and in this presentation. It's just 15 minutes. I kind of do part of that, and I deconstruct complementarity and I say what's wrong with it. And I think hopefully this will provide an opportunity to have a discussion. I've noticed that in Israel, in particular, people are very attuned to this complementarity discussion because, of course, of the ICC's investigation in Palestine, Israel. And so I'm not going to actually explain a lot of things that I'm going to unfortunately have to take for granted that people are familiar with sort of Article 17 of the Rome Statute, the two-step test. So inactivity versus unwilling and unable. I'm not going to explain that. I'm going to jump right in and talk about it. And the way I want to do this is so relational complementarity is an alternative theory of complementarity, to summarize what the argument is. I argue that the current case law on complementarity is wrong, not as a matter of outcomes, but as a matter of procedure. And the core claim that this paper makes, but this is part of the relational complementarity theory, is that the two-step test is wrong. There is no two-step test in the Rome Statute. That is an invention that has been foisted upon the court by a variety of actors with good intentions, but it leads to absurd outcomes. And the paper tries to explain why the current case law is absurd. And I think the best way to do this is to use the UK-Iraq decision that was reached, that was made recently by the Office of the Prosecutor, as many of you will know. In December 2020, the then prosecutor, of course, we now have a new prosecutor, Fatou Bensouda, decided to not seek authorization to open an investigation because, and her core argument was that she was unable to substantiate the United Kingdom's unwillingness genuinely to prosecute. And this is key, right? So she was unable to prove, to substantiate this unwilling genuinely to prosecute prong of the complementarity test, right? And this is very important for my argument, because what I essentially argue is that the ICC is never going to find a state unwilling genuinely to prosecute because of the two-step test. Because of the way the two-step test is set up, it is impossible to find a state unwilling genuinely to prosecute, and therefore the test is manifestly absurd under Article 32 of the Vienna Convention on the Law of Treaties and should be abandoned as a matter of law. So that's summarizing it. But just to come back to the UK-Iraq decision, the UK-Iraq decision, we know this from the prosecutor's decision, but also from statements that were made after the decision was published. After the decision was published, Rod Rastan basically acknowledged this in one of the meetings that they had on YouTube. Of course, now everything's happening online, so people can find this. The Office of the Prosecutor conceded that the reason they didn't seek authorization to open an investigation was because they feared an Article 18 challenge from the UK. And had the UK challenged, and inevitably they would have done, the Office of the Prosecutor feared that they would not be able to substantiate that the UK was unwilling genuinely to prosecute. And so, the problem here that I highlight, and partly the paper is about this, and then the theory of relational complementarity tries to sort of resolve this problem, to find a way out. The problem is that we have a conceptual, I believe, at the heart of the Rome Statute right now, at the heart of the complementarity test case law, we have a conceptual cul-de-sac. And the problem that we have is that in this case, the Office of the Prosecutor is saying, we're not going to open an investigation because we can't prove that you are unwilling genuinely to prosecute. But of course, if you don't open an investigation, you don't have investigative powers. And so you're obviously never going to have that information that you need to prove unwillingness genuinely to prosecute. And this should sound familiar to people who follow the ICC, because we had a very similar problem when the Afghanistan decision was made, the pretrial chamber decision in April or March 2019, I believe, when the pretrial chamber said, look, we're not going to open an investigation into Afghanistan because we know that the United States and Afghanistan likely are not going to cooperate, so let's not bother, because there's no prospect for cooperation. So in the interests of justice, we're not going to even open this investigation. Of course, this was heavily criticized at the time because you're rewarding a state for not cooperating. You're not going to open an investigation because you fear that the state isn't going to cooperate. Well, we have the same problem here with the UK. The UK, does a bunch of stuff, but because the prosecutor can't prove unwillingness genuinely to prosecute, she doesn't even open an investigation to show that that indeed the UK was unwilling genuinely to prosecute. So anyway, let me now get to sort of some of the claims that I make in this paper. I argue that the two-step test, the two-step test, so is inaccurate. It's wrong as a matter of law, policy, and drafting history, right? So this is important. I make three claims that, first of all, the two-step test is not supported by the drafting history. I don't do this in this paper, but I do it in general in my research. I argue that it's legally unnecessary under the Rome Statute. And then most fundamentally, as I already intimated through the lens of the UK-Iraq decision, I argue that the two-step test is irreconcilable with the object and purpose of the International Criminal Court, of the Rome Statute. The Rome Statute was essentially set up, sorry, the ICC was set up, the Rome Statute was created for the ICC to intervene precisely in situations where the state is unwilling genuinely to prosecute. And yet under the current case law, we have the opposite result, which is that the unwilling genuinely to prosecute prong is never the reason cases are admissible. Inactivity is always a reason, but unwilling genuinely to prosecute is never the substantive reason why the ICC actually prosecutes, opens an investigation, or prosecutes a case. And one of the things that I make, and this is just a sort of food for thought for people, because we can't discuss everything here, but one of the things that I find interesting in the current discussion around admissibility and the Rome Statute is that scholars who defend the two-step test emphasize that the law is clear. If you look at Article 17, there's a two-step test, right? If the state is inactive, then the case is admissible. The law decides everything. And what I find interesting about this conversation, and this is one of the things that my paper brings out, is that admissibility is never a question of pure law. It is a question of law and policy. And even if you ground your admissibility case law decisions in law, it's actually about policy. And so I cite Yuval Shani. I'm not going to cite him now, but he makes this point that contrary to jurisdiction, which is a question of law, admissibility is always essentially a question of policy, and claiming otherwise is disingenuous. It's simply not. It's not what admissibility is about, right? And so what the paper does, getting sort of to the heart of this paper and the claim about inactivity and unwillingness, so that for everyone to be able to sort of wrap your heads around the core claim that I'm making here. I distinguish between four scenarios in this paper where this is what is theoretically possible under the current inactivity, unwillingness. Sorry, how much time do I have?
Your 3 minute will be in 2.5 minutes.
Oh, okay, so 5 more minutes. Okay, so I can run through this. This is what I wanted to discuss, but essentially there are four scenarios, and so bear with me. This is going to be a little dry and technical, but the 4 scenarios are that under the current case law, right? So you have inactivity first, and then you go to the unwilling, unable, genuinely test. So the 4 scenarios are that a state is not investigating or prosecuting a suspect for substantially the same conduct, and it is not shielding. The case is therefore admissible because the same case is not being prosecuted. A state is not investigating or prosecuting a suspect for substantially the same conduct, and it is shielding. The case is admissible because the same case is not being prosecuted. The 3rd scenario is that a state is investigating or prosecuting a suspect for substantially the same conduct, and it is not shielding. This is the situation where the case is inadmissible. And then the 4th scenario is that a state is investigating or prosecuting a suspect for substantially the same conduct, and it is shielding. Again, the case is admissible, but the case is admissible here. This is the first time that the case is admissible under the 2nd prong, the unwilling genuinely to prosecute prong of complementarity. Now, the claim that the paper makes is fairly straightforward. You have these 4 scenarios in theory for case admissibility, and so 3 scenarios for case admissibility and one scenario for case inadmissibility, right? Inadmissibility is when the state is prosecuting the same case and it is not shielding. Now, the point that I make in this paper is that we're never going to get to a situation where the reason that the prosecutor opens an investigation or the reason that a case is being prosecuted is the 4th scenario. The 4th scenario where the state is prosecuting the same person, but it is shielding, and therefore the case is admissible. And I say that we're never, I mean, and this is very technical, sorry if it's difficult to follow, but the point is basically that under the 2-step test, the only way you get to the inadmissibility, the unwillingness genuinely prong is for the state to prosecute the same suspects. But if the state is prosecuting the same people, the prosecutor has basically said, look, I can't prove unwillingness. And so we never get to that prong of the complementarity test. And if the prosecutor really wants to open an investigation or have a case declared admissible, what the prosecutor is going to do is the prosecutor is going to rely on the inactivity test because it's much easier to make a case admissible by distinguishing the case from what the state is doing. And so you have this conceptual cul-de-sac whereby the only situation where a case is admissible is because of inactivity, and the sort of the raison d'etre of the in my view, one of the main reasons that we have an international criminal court, that reason never gets invoked to substantiate a case of admissibility, right? Because the prosecutor is never going to rely on the unwillingness genuinely to prosecute prong, because again, as she already demonstrated in the UK investigation, she just doesn't have the evidence to make that case. And so I mean, to me, this becomes sort of a conceptual cul-de-sac, and you know, I'm mindful of the time. I'm trying to find a way to explain sort of the points that I want to make as briefly as possible. But essentially, the argument that I make is that this is a manifestly absurd situation. That this interpretation leads to manifestly absurd results. It is irreconcilable with sort of the public policy rationales underlying the Rome Statute, and therefore we need to, in the long run, we need to abandon the two-step test. The two-step test leads to absurd results, and we need to find a different way to do this. And the reason we need to do this, and I'll end on this note, the reason we need to do this is because unwillingness genuinely to prosecute is a fundamental part of the Rome Statute. And we want the ICC to prosecute cases, to open investigations because of that prong. I mean, this is why the court exists, so that the state is labeled unwilling genuinely to prosecute, to investigate or prosecute. There has to be a naming and shaming element to the complementarity principle. And if it doesn't, if that procedurally, that naming and shaming element is impossible, that means there's something wrong with the way the Rome Statute has been interpreted, right? Again, my argument is that it's manifestly absurd to argue that an interpretation that leads to the fundamental sort of essence of complementarity never being used in practice is somehow a correct interpretation of the law, right? And so relational complementarity, this is what's not part of the paper, and I won't discuss this, but relational complementarity is a theory that I propose, beyond this paper, where you integrate inactivity into the unwilling and unable test of the Rome Statute, so that is what the prosecutor, the judges, the state, the defendant are always arguing about when it comes to admissibility challenges, right? So I think I'll stop there, and hopefully, this is a little technical, but hopefully it was possible to follow, and I'm looking forward to your comments, and I look forward to your questions. Thank you.
Okay, thank you, Patrick. And thank you very much. And there are questions to come. Mara, please, 15 minutes, the floor is yours. And I repeat, if anyone wants to sign up for questions or raise their hand, please feel free.
Great. Thank you so much for chairing, and thanks to the Minerva Center for the opportunity to be a part of this important conference. I'm Mara Revkin, currently a fellow at Georgetown Law, and the paper I'm presenting today is co-authored with Kristen Gao at the University of Gothenburg. And we use an original survey experiment to study how variation in the severity of punishment affects public opinion toward reconciliation and reintegration after war in the case of Islamic State collaborators in Iraq. And I'm just going to share some slides with you now. This is actually a particularly good time for us to be presenting this work. Sorry, just bear with me. I'm going to share a portion of my screen. I'm actually returning to Iraq on Friday in 2 days for some related work on repatriation of Iraqis affiliated with ISIL who have been in camps in northeast Syria. And Kristen has other work in progress in Iraq. So this is just a really good time for us to get feedback as we start new projects building on this paper. Sorry. I want to start out by showing you a few images that I hope provide a very small window into the experiences of Iraqis who lived through the Islamic State's harsh rule in Mosul, followed by what has been described as the deadliest urban combat since World War II. These are drawings by Iraqi children who fled Mosul during the 2017 battle to recapture the city and were living in nearby IDP camps where I was doing field research at the time. So on the left, we see civilians killed by an airstrike, and on the right, Islamic State members are shown executing 2 prisoners. One is being shot by a firing squad, and the other is being drowned alive in a cage. These images are very disturbing to look at, but I think they're an important reminder of how devastating this conflict has been for Iraqis. And one of the contributions we hope to make with this research is to provide empirical support for the importance of listening to the perspectives of victims and including them in transitional justice processes. The policy problem motivating this paper is that incarceration remains the dominant model of criminal punishment, particularly in terrorism cases, despite a growing body of empirical research which suggests that prison often fails to achieve its purported objectives and also has some very significant counterproductive consequences. So we know that prisons are extremely costly, both from a human and economic perspective. Prolonged incarceration endangers prisoners' safety and human rights, harms their mental and physical health, and makes it very difficult for them to access education, employment, voting, and many other basic rights and services after their eventual release. Another concern is that there are significant racial and socioeconomic disparities in sentencing, so these harms disproportionately affect historically disadvantaged social groups. At the same time, many studies have called into question the effectiveness of incarceration for achieving its purported goals, including deterrence, incapacitation, and rehabilitation. So for example, incarceration doesn't necessarily achieve incapacitation because it's still possible to commit crimes inside of prisons, such as phone scams, and there are numerous examples of criminal gangs and terrorist organizations that were originally formed within the walls of prisons, including the white supremacist Aryan Brotherhood and the Islamic State, whose former leader is believed to have been radicalized during his time in an American-run prison in Iraq after the 2003 invasion. So given growing evidence that the human and economic costs of incarceration probably exceed its purported benefits, we think there's a need for more empirical research on how the objectives of punishment might be better achieved through more humane and less costly alternatives. Of the different objectives of punishment, this study focuses specifically on reintegration. Studying the effects of incarceration on reintegration is very important because the vast majority of nonviolent offenders will eventually be released and will then face the challenge of reentering society. An important but understudied factor in the success or failure of reintegration efforts is public opinion toward former offenders. If community members distrust and fear former offenders, the resulting stigmatization makes it very difficult to rebuild social relationships and find employment, which then increases their risk of recidivism. Historically, proponents of incarceration have relied on an untested empirical assumption about public opinion, which is that prison is supposedly necessary for former offenders to prove to society that they have successfully been rehabilitated and paid their debt to society. But this theory of prison as repayment of a debt to society is problematic because we don't actually know very much about what communities themselves consider to be necessary conditions for return and reintegration of former offenders. So if we were to actually ask communities about their preferences, do they in fact demand long prison sentences as the theory of prison as repayment of a debt to society predicts? Or on the other hand, would they be satisfied with much shorter prison sentences or alternative non-carceral sanctions such as community service? We tried to answer this question in the context of Iraq, which is an important case in which to study the relationship between punishment and reintegration due to the very large number of nonviolent Islamic State collaborators, as they are often called, who are currently in prison there. Between the rise of the Islamic State in 2014 and its military defeat in 2017, the group functioned as a de facto state and operated a range of institutions, including courts, sanitation departments, and bread factories that not only sustained its military operations, but also provided services to the local population. So when the Islamic State lost its last territory in Iraq in 2017, it left behind a population of around 5 million people, mostly civilians, who had been living under its rule for more than 3 years. Many of these people were victims of the Islamic State's human rights abuses, but there was nonetheless a widespread assumption that anyone who had lived under the Islamic State's rule for an extended period of time and had therefore participated in its economy was presumptively complicit in its crimes by providing material support for terrorism. As a result, the Iraqi government took a very harsh approach to prosecuting individuals who were accused of supporting the Islamic State in any capacity, whether as combatants or civilian collaborators. In the paper, we call this a one punishment fits all approach, and it has resulted in the mass incarceration of more than 20,000 Iraqis on terrorism-related charges since 2014 in very procedurally flawed trials with a 98% conviction rate. I've been able to observe some of these trials myself in Iraq and saw that verdicts are often reached in less than 10 minutes on the basis of circumstantial evidence, or even worse, evidence obtained through torture. Although fighters are almost always sentenced to death, most non-violent civilian collaborators, such as people who baked bread in bread factories, are sentenced to long, but still less than life prison sentences, often between 10 and 15 years. And therefore, these people will eventually be released, and they will face the challenge of reintegration into their former communities. Given the human and economic costs of incarceration I mentioned earlier, as well as the ongoing COVID-19 crisis, which is particularly deadly in prisons and other congregate living situations, the question of whether such long prison sentences are actually helpful for eventual reintegration and whether shorter or non-carceral sentences might be equally or more effective is particularly urgent in Iraq. We developed two different hypotheses about the possible effects of punishment on reintegration. The first hypothesis, based on the theory of prison as payment of a debt to society, predicts that long prison sentences will increase the community's willingness to allow reintegration of former offenders in comparison with shorter prison sentences. The second hypothesis, based on restorative justice theory, predicts that restorative sentences like community service will increase the community's willingness to allow reintegration of former offenders in comparison with no punishment. We then tested these hypotheses with original data on Iraqi public opinion toward hypothetical nonviolent civilian Islamic State collaborators through an experiment that we embedded in a random sample household survey of more than 1,400 residents of the Iraqi city of Mosul, which was the Islamic State's former capital. To do this, we trained a team of 10 Iraqi researchers from Mosul to conduct the survey door to door with computer tablets in March of 2018, which was just 8 months after the city was recaptured from the Islamic State. Here's a map of our survey locations in Mosul. We used a 3-stage randomization procedure, first randomly selecting 47 of the city's 209 neighborhoods, highlighted on the map in dark green, then a random walk method to select houses, followed by random selection of an adult member of each household. To give you a sense of what Mosul looks like, this is a photo I took when I was last in the city in December of 2019. Many neighborhoods are still in need of significant reconstruction, even though it's now been almost 4 years since the city was liberated. I show this photo just to re-emphasize my earlier point that even though residents of Mosul have been widely stigmatized for their perceived collaboration with the group, this is a community that suffered enormously during the Islamic State's rule and continues to suffer its long-lasting consequences. Since this is obviously a very vulnerable population, I'll also note here that our study went through a rigorous IRB process to minimize risks to respondents, and I'm happy to talk more about the ethics and security issues in the discussion. Returning to our methodology, survey experiments are a research design that randomly varies the wording of part of a question embedded in a survey so that we have a control group and treatment groups of respondents who see two or more slightly different versions of the same question. And this enables us to estimate the causal effects of one or more independent variables on a dependent variable. And in our case, the independent variable is punishment and the dependent variable is a respondent's support for reintegration. Our survey experiment asked questions about 3 different hypothetical nonviolent Islamic State collaborators: a cook for fighters, a woman married to a fighter, and a janitor. For each of these 3 scenarios, the survey was programmed to randomly assign a punishment from among the 4 options listed here that range in severity from no punishment up to 15 years in prison. After the respondent was presented with each of the 3 collaborator profiles and their randomly assigned punishment, the field researcher then asked the respondent, given the punishment that this collaborator received, would you allow him or her to return to your community and become your neighbor? This figure shows the results for linear regression. Overall, 30% of respondents were willing to allow the reintegration of former collaborators, which I think is a surprisingly high percentage, given the severity of the crimes that the Islamic State committed against the population in Mosul. So the vertical y-axis here shows the different types of punishments, and the horizontal x-axis shows the effects of these different punishments on survey respondents' willingness to allow the reintegration of a given collaborator on a scale from 0 to 1, where 0 represents refusal and 1 represents acceptance of reintegration. So what do these results mean for our 2 hypotheses? At the upper right, we see, contrary to hypothesis 1, long prison sentences do not significantly affect respondents' willingness to allow the reintegration of collaborators in comparison with more lenient alternatives. So this just means that those who serve a 15-year prison sentence are not any more likely to be reintegrated than those who receive no punishment at all. A shorter prison sentence of 3 years does appear to have a very slight positive effect on respondents' willingness to allow reintegration, but this result loses statistical significance when we test its robustness with a different model. Although we did not find support for hypothesis 1, we do find some evidence in support of hypothesis 2, predicting that restorative justice approaches should increase the community's support for reintegration. So we find that a restorative sentence of 6 months of community service has a small positive effect of 4 percentage points on respondent support for reintegration, and this finding remains statistically significant after robustness tests. So to summarize these results, the size of the effect of 6 months of community service is greater than the effect of a 15-year prison sentence, and similar in magnitude to, but more statistically significant than the effect of a 3-year prison sentence. I'm now going to present what I think are the strongest results. After the survey experiment, we asked 3 follow-up questions only to respondents who initially refused to accept the reintegration of former collaborators, which, as I mentioned, was a significant majority of 70% of the sample. And the idea here was to find out if we could change the minds of people who were initially opposed to reintegration by offering restorative and community-based justice mechanisms. And we find that among respondents who initially rejected reintegration, 8% are willing to change their judgment and support reintegration if they are asked to do so by their tribal or religious leader. And another 10% were willing to support reintegration if the former collaborator completes a non-carceral rehabilitation program. So together, the combined effects of a community leader's endorsement and a rehabilitation program persuade around 15% of people who were previously opposed to reintegration to change their minds, which we show here in the green segment of this pie chart. And this suggests that restorative or community-based justice mechanisms can be very helpful in increasing public support for reintegration. In conclusion, we hope that this research makes contributions in 3 areas. First, previous research suggests that state-led, top-down transitional justice processes are often ineffective in advancing the goal of sustainable peace because they tend to be insufficiently inclusive of diverse perspectives, particularly the voices of victims, and they're also often heavily shaped by the preferences of political elites on the winning side of the conflict, which leads to the problem of victor's justice. In contrast, our study uses a very bottom-up methodology to illuminate the experiences and attitudes of people directly affected by conflict in the place where the conflict happened. Survey experiments like those we conducted in Iraq could be replicated in other post-conflict settings to inform evidence-based transitional justice policies that reflect not only the interests of the state and political elites, but also the interests of victims and marginalized communities. Second, we think that this research is relevant for debates about sentencing reform in Iraq and potentially in other contexts, because we find that in the case of Iraq, community members do not seem to view long prison sentences as a necessary condition for reintegration of former offenders, even though this is a case where reconciliation and reintegration are very difficult due to extremely high levels of fear and anger against the Islamic State as a result of its severe crimes against the local population, which included using civilians as human shields. So given our findings in Iraq, we expect that public opinion should be even less punitive and even more amenable to the reintegration of individuals convicted of crimes much less serious than collaboration with the Islamic State, such as drug possession or petty theft. And we also think our findings have some implications for other criminal justice systems that rely heavily on incarceration, such as in the United States. But of course, I'll note here that the case of Iraq is very unique, and there are important limits to the generalizability of our findings to other contexts. And third and last, we found some very promising evidence that restorative and community-based justice mechanisms, such as community service and endorsements by community leaders, can help change public opinion positively in ways that decrease destigmatization of former offenders and facilitate their successful reintegration, which has important implications for policy and programming on non-carceral rehabilitation of former offenders in Iraq and beyond. Thank you so much for listening, and we welcome your comments and questions also by email if you don't have time to ask them today. Thanks so much.
Thank you very much, Mara, and thank you both. So I'll start with some comments and questions for both of you. So Patrick, you are challenging something deep in how the ICC is functioning and the Rome Statute, and basically it's a challenge for international lawyers and that are specifically dealing with the ICC. But as you, I think, rightly say, and I think there will be not so much debate about that, the question is indeed a question of policy. Therefore, and this is why I started with the challenge that prosecutors face, and especially prosecutors in such a young court system. So the question is, again, and I return to you, the question of policy. If we do accept that there is a reason why it is being said in the Rome Statute, and yet the prosecutor and the ICC afterwards will have a dilemma. First off, those are the hard cases to prove, right? So those are the hardest cases for many considerations. First, because it's harder to prove motives instead of something clear cut than based on lack of activity. So this is a one way. Another way is what are the who are the other side in these cases, and those are generally will be the more powerful allies, right? The ones that are supporting, like the UK, like the US, probably Israel, right? That will be relevant here as well, and it will be a great issue that will come. So this is policy considerations from the court. You can see why they have good reasons, not of the prosecutor, of course, not to touch those cases. But another one comment about your assumption that we want the court to open such cases, right? And maybe, and I think even in transitional justice, it has more and more moving into the idea of positive complementarity, right? That actually what we want to achieve is that states themselves will open those cases, right? So those are my thoughts and comments. And of course, it's very provocative and interesting, and it's an open, and I'm looking forward to hear your last chunk that was not delivered in the paper. And Mara, for you, it was a really full of information, and I guess that you have so much information in those research. So first of all, it's really interesting and impressive. So I had several comments or questions, not comments. First, I was wondering if you checked ethnicity within your criteria, and how much this is something that is in the head of people, and especially from the different between the local population and people that come from outside and look at the situation. And I was wondering what surprised you, like what was the things that really surprised you, if there were things that did not came in the statistics, but still you saw that you had interviews as well. So if there are things that came up there that will be interesting to hear about that. And one last thing, I read that you were also working in Syria, and I was wondering if you can compare or tell anything about what's going on in Rojava, which is totally different idea of the judicial system. And okay, so thank you both.
Should I go first? Yeah. No. Thank you for those comments. I think you're addressing precisely the issues that I want to also address in this project, not necessarily in this paper, because as you rightly pointed out, I don't necessarily get to that part of the argument in what I submitted. But the theory of relational complementarity is certainly about those policy dilemmas and those policy choices. And the only thing I would say about this is that I don't think this is only about more powerful states. I think that, of course, it applies to the UK, Israel, the United States, but it's also about, a case like Kenya. The reason the Kenya investigation was opened is because Kenya was shielding Uhuru Kenyatta from domestic from a domestic accountability process. The 6 suspects were prosecuted by the ICC, not because Kenya was inactive. It's because Kenya was shielding, and everybody knows this. And when I speak to people at the office of the prosecutor, they smile and they say, of course we know that they were shielding, but we use inactivity as the argument, the legal argument. It's the legal argument, the lever that we have, and so we apply it, and we pretend that it's about inactivity. It worked. It worked in the Kenya case for a variety of reasons that we can could discuss another time. The problem is that when you try to apply the same argument to a situation like the UK, all of a sudden you see the limitations of this inactivity argument, right? And the limitations aren't so much that the UK was not shielding, because the UK was likely shielding as well. The problem is that the prosecutor was confronted with the fact that the UK was going to push back very hard, and basically the prosecutor, again, for policy reasons, I think, as you rightly pointed out, decided, I'm not going to go there. I'm not even going to try to open an investigation, because then I'm going to have to, the Article 18 challenge, I'm going to have to substantiate this in court. And so, it creates perverse results, but the problem exists not only for powerful states. Going forward, it's a roadmap for states like Kenya that in the future could use the same tactic to basically avoid any investigation, right? So I think that's important to point out. With respect to the assumption, I think this ties in with sort of what the previous point you said, but the assumption is actually that we want positive complementarity, and I agree with you. But the reason my counter argument is that the way you get to positive complementarity is not by pretending that the state is being inactive. It's by saying, look, I mean, these are the problems. You're unwilling to prosecute. You're shielding, and you need to do better. And the ICC can perform almost sort of like an educational function if the admissibility decisions are made on the basis of, as you noted in your first question, the problem of motives. And there you explain, look, we have concerns about why these cases aren't proceeding, and there's an educational function, and I think it also spurs on positive complementarity, because the state can theoretically do better. But the way you encourage the state to do positive complementarity is not by invoking the inactivity test. It's by saying, look, we think what you're doing here is a perversion of justice, and saying it openly, and that way engaging starting some kind of dialogue. But I realize that, of course, this is contentious. Some people will say, but that's not how diplomacy works. The way diplomacy works is that you pretend that everything is okay and you don't shame the state. And so, there's this sort of push-pull here. How much naming and shaming can be done without alienating the state, versus the alternative, which is diplomacy, and you try not to say openly what everybody knows, and by not saying it openly, you give the state an opportunity to do better without losing face, right? So, of course, these are real policy dilemmas, and I don't have all the answers, and obviously the paper is never going to provide those answers, but this paper, this whole theory of relational complementarity, is intended to at least trigger this discussion, so that we start having these conversations about what is the best way forward, because the way things are going right now is not particularly inspiring. So yeah, I'll stop there.
Thank you, Patrick. We have, of course, much more to talk about that, but not now. Mara, I pass to you. Thank you.
Thanks so much for these great questions, Limor. So first, on asking about questions about ethnicity and religion of the participants in our survey, I should have clarified this, but our sample was exclusively Sunni Muslim Arabs in Mosul because that was the demography of the city at the time we did the survey. The Islamic State had severely persecuted. So prior to 2014, Mosul was around 60% Sunni Arab with minorities or 70% Sunni Arab with minorities of Shia Christians and other groups, but they were forced to flee the city because of the Islamic State's persecution of those minorities. And so what this is really sort of a study of the attitudes, so preferences for reintegration and justice among the Islamic State sort of own in-group of members and the local population that it governed. And we would definitely expect the results to be very different if we ran the same survey with some of these other religious and ethnic groups that were much more severely victimized by the Islamic State, such as the Yazidis, who were, as we know, subjected to a horrific genocide. So in terms of, finding some support for forgiveness and reconciliation in this community in Mosul, we definitely would expect to see much lower levels of forgiveness and reconciliation among Christians and Yazidis. And my co-author, Kristen, is in the process of conducting some follow-up studies with more diverse samples in Iraq, and we'll be able to actually see to what extent these findings do and do not generalize to other social groups. In terms of what surprised me on the survey, it was really the finding that just a few months after the conflict had ended, this population that had been extraordinarily victimized by the Islamic State was surprisingly more forgiving and open to reconciliation than I had expected, given that this is a population of people who had been used as human shields, and the Islamic State had mass executed them by the hundreds as they were trying to flee the city during the battle. And so I did come in to the study expecting to find extremely high levels of retribution and demands for revenge, and we do see that in the harsh in terms of unwillingness to forgive. In other work that Kristen and I have done, we find preferences for very, very harsh punishment of fighters and other types of collaborators who are most involved in military operations. But qualitatively, I've done interviews with some of the wives and children of Islamic State members who have been living in IDP camps. And I remember women telling me that they hoped that they would be able to stay in those camps forever, despite having to live in really small tents under very difficult humanitarian circumstances, because they were terrified that as soon as they returned to their former communities, they would be killed and they would be subject to honor killings and other retaliatory violence, and their houses would be burned down because of their perceived complicity in the Islamic State's crimes. And so given what I knew sort of about the fears among collaborators about what would happen to them upon return, it was surprising that when we actually surveyed this random sample of Mosul residents about their views, we found less demand for revenge and retribution than we'd expected. In terms of differences between the contexts in Iraq and Syria, just a couple of thoughts on this. So my dissertation was about the Islamic State's system of governance that spanned both Iraq and Syria. And one of the findings was that the Islamic State had been initially successful to some extent in building local support in both of these countries because they were able to exploit long-standing historical grievances with state-perpetrated injustice by the Syrian and Iraqi governments, including human rights abuses, particularly in Syria, and corruption. And some of those grievances have been expressed in the 2011 Arab Spring protests, but when those peaceful demonstrations ultimately were unable to yield sort of meaningful reform, the Islamic State and other armed groups began to appeal to populations that were unable to achieve change through peaceful means. And that was a major factor in the initial rise of the Islamic State. So that's just to say that there is an important link between sort of historical injustice and support for the Islamic State that I think is important to take into account in future transitional justice processes. And my current work in Syria is going to be looking specifically at the issue of repatriating Iraqi nationals who have been living in IDP camps in the north. And so I am not working specifically on the issue of trials by Kurdish courts in the north. I know that that process is ongoing. I think it's a really important area for future research, particularly because that is the Kurdish de facto state is one that is not recognized by the international community, and it's very unclear what law operates there at all. So I'll stop there, but thank you so much for these questions.
Thank you very much, Patrick and Mara, for those interesting presentations, very much, that actually close our intense 3-day conference, international conference, how Zoomland enables us to be in different places and still be and listen to each other. This is great. Unfortunately, we could not sit in the same room, but I hope next time it will be possible next year. So for our last 2 minutes, what I want to say, I have 2 things to say. First, I wanted to mention a new initiative that both Minerva centers in Tel Aviv and Jerusalem are about to take, which we will outreach to researchers. In transitional justice, we want to make some kind of a bibliographic or a resource for researchers on transitional justice in general, but in particular with those that are writing on this area, on Israel-Palestine. And so you will be reached, some of you at least, that are writing on those issues, and we will be happy to share them in the future, hopefully in the near future. This is one thing. And the other, if there are participants now that want to open their cameras and say one last word for closure of this conference, I will be happy, and I'm inviting Danny, maybe you want to say something. So I would like to say that thank you very much, both for our 2 panelists and for all the presentations that we heard in these couple of days. And I look forward to our next sessions in the future. Have we anybody that wants to say? Danny, do we want to say something? Or Patrick and Mara, would you like to say something?
No, just that I learned so much from this conference. I'm really grateful to be included and hope we get a chance to meet in person sometime.
Thank you, Mara. Patrick, you're feel free.
No, I'll let the organizers speak, but thank you so much for the opportunity. Yes.
Okay, thank you, Danny. Yeah.
I just want to thank everyone, the speakers from all across the world. Although Zoom is amazing, it's still logistically very complicated for everyone. It was an amazing conference. I learned a huge amount. The discussions were really stimulating, and I want to thank all the organizers in Tel Aviv and Jerusalem, many people involved in organizing this. Lior Achel in Tel Aviv, Tomer Einat, and many people in Jerusalem, Anat and Dari, who are in charge of all the administrative and technical logistics, which are crucial. The internet fell in different places, of course, during these 3 days, and it passed almost without notice. So that's a credit to them. And the academic committee of the conference for all their work. We remind everyone that we encourage you to submit papers to the Israel Law Review, our Cambridge University Press Journal of International Public and Human Rights Law that we publish at the Minerva Center. And we look forward to our next annual conference, joint conference, which will be in a year's time. Liora, do you have something you'd like to add?
I just wanted to say how much I enjoyed, but I wanted to extend special thanks to Irit for the idea, for pushing for it, and for bringing it about. I think it was, I learned a lot, so thank you.
Thank you so much for everyone who made it happen, really. And who knew that procedure would be so fertile?
I knew.
I knew as well.
Okay, so I'm about to declare the international conference closed. Thank you, everybody.